Now, I'm really pleased to introduce our final panel of the day, and it's my pleasure to introduce my colleague, Robyn Griffin, Managing Director at Huntington, and she will moderate today's session about securities. Go ahead, Robyn.
Okay, I think we are getting everybody coming up there. Okay, terrific. Well, thank you, Chris. So I am Robyn Griffin, Managing Director at Huntington Bank in our National Settlement team. And so I have a terrific group of panelists here together today that I will introduce in a minute, but first want to just discuss what the key topics that we'll be talking about today. So there's four main areas that we're going to look at. First of all, looking at the globalization, the increased globalization of securities litigation. Next, we'll move into discussing the debate between federal versus state court for securities cases. And then a very hot topic right now is looking at the impact of COVID with securities cases. And then finally, looking at trends now and going forward with securities litigation. So with that, I want to introduce my esteemed panel. So first we have Steve Cirami, who currently leads the corporate action and class action teams for Broadridge Financial Services. Prior to joining Broadridge, Steve served as the global head and chief operating officer of one of the largest claims administrators for class action and mass tort. Since graduating Duke Law School in 1998, Steve has served in nearly every capacity of the class action process. So next we have Dean, and Dean is the senior reporter covering the securities industry for Law 360, and primarily writes about class action litigation, SEC enforcement, and the evolution of securities law. Prior to joining Law 360, Dean was an award-winning print and digital journalist reporting on criminal justice and local business in Virginia. Next, we have Jeroen van Kwawegen. Jeroen, you can maybe help me with that, the pronunciation.
You did great, just great.
I tried many times to figure out how to pronounce that, practice that. Is currently a partner at Bernstein, Litowitz, Berger, and Grossmann, and serves as the co-head of the firm's Department of Governance. He's also the head of the firm's European client development efforts and oversees the firm's global securities and litigation monitoring team. Jeroen has been widely recognized within the legal industry for his accomplishments, including most recently, Law Dragons named him one of the 500 leading lawyers in America in 2019, which is a distinguished honor as it's the only shareholder litigator from Europe to receive this professional recognition. And finally, we have Glenn Vanzura, who is currently a partner at Mayer Brown, focusing his practice on securities litigation, complex business litigation, white-collar crime defense, and internal corporate investigations. His most recent matter, Glenn first chaired a successful arbitration in which his clients enjoyed a complete defense victory. Glenn is active in his community, including service on the Los Angeles County Bar Association and pro bono matters, including representation of low-income tenants and former members of the U.S. Armed Services. So with that, I would like to start our discussion on our first topic regarding the globalization of securities cases. So one thing, I just want to make sure you all are unmuted so that we can hear all of you. So the first thing is, in this post-Morrison world, we see several key trends that have developed. On one side, first, there's significant increase in filings and settlements abroad, outside the US, like the Fortis settlement, Volkswagen, RBS, and others. But then also, we see this trend in 2020 where we're trending towards the highest volume of securities class action filings against non-US issuers in the US. So Jeroen, would you start us off with your perspective on kind of this trend going on?
Sure, be happy to. First of all, thank you for having me on this panel. I would be remiss if I wouldn't start by saying the views I'm about to express are my own, not my firm's or my partner's. But that also allows me to be completely candid, and you can just take it out on me. To start off, yes, the internationalization of securities class actions is continuing. I think many people in the audience know this, but following the 2010 decision by the US Supreme Court in National Australia Bank, it is no longer the case that securities are covered by the US securities laws unless they were traded in the United States. And what that means is that if you are a large institutional investor and you traded in securities on the London Stock Exchange, you no longer have a claim under the US securities laws. And by the way I described this, you probably gathered that this does not just affect European investors or Asian investors, it also affects American investors, right? If you are CalPERS or CalSTRS or another large institutional investor, you're not executing your trade because you're looking to buy a lawsuit. You're executing your trade because you want to get the best execution or because your portfolio manager made an allocation decision. And so following the 2010 decision by the Supreme Court, there was a demand by investors to find alternative ways to seek redress for fraud. And consistent with their local philosophies and local approaches, different countries around the world are starting to fill that void. And so when you see what's happening is over time, you see increasing settlements abroad that are actually significantly higher than before the 2010 decision. So for example, earlier this summer, there was a decision announced in Steinhoff, which is a South African company incorporated in the Netherlands, and they were offering to pay $1 billion in connection with securities claims there. I think, Robyn, you already referenced the RBS case. There's the Fortis case. And so you have a lot of headline numbers of increasing settlements abroad that are actually very significant. And my prediction way back when was that this was going to happen. And my prediction now is that you're going to see more and more of them in the future. I think it is inevitable because as long as there's fraud, investors will try to find a way to recover the damages that are caused by the fraud. And there will be fraud as long as there's greed. And so I have no doubt that this will continue. Now, I don't want to overstate it though. I think that these non-US class actions or these non-US actions get a lot of billing time, and it is a very important development. But even today, 90% or more of the recoveries in the world are here in the United States. But that percentage will decrease over time. You know, one of the things that we talked about before this call is, you know, obviously outside the United States, with some exceptions like Australia and Canada, but outside the United States, the model is really an opt-in model, not an opt-out model that we have here in the United States. And that incentivizes shareholders to just opt in, because if you do nothing, you recover nothing. And so I see with a lot of our clients, and I also see that with other investors, that they just opt into a lot of cases because there's, from their perspective, little risk, little time incentive. And if you do nothing, you get nothing. That is another reason why I think that these settlements are going to continue to grow over time, because even investors with relatively small amounts at risk or small amounts to recover will opt in on the theory that, you know, if you do nothing, you get nothing. The third thing I promised that I would touch on is a little bit the Netherlands. I am now one of your fellow Americans since this summer, but originally I came from the Netherlands about 20 years ago. And the Netherlands is important because most of the very big settlements that you hear about, Steinhoff is a good example, but Fortis, which is, I believe, the largest non-US class action to date, they are structured and done through the Netherlands. And what is interesting is that in the Netherlands, you don't really have a lead plaintiff like we have here in the United States, you know, where we have the PSLRA since 1995, and the investor with the largest loss is presumptively going to be leading the case. What you have in the Netherlands is a different principle. It is a foundation, a not-for-profit organization that is going to be leading the charge, and if it is sufficiently representative, then can present a global settlement based on an opt-out system like here. And so there are a lot of like interesting developments there, because the question then becomes, well, who is actually running this foundation, right? And why do you have that system? I'm happy to talk more about that. But one answer is the foundation system is partially just rooted in the Dutch culture and legal history. And it's also partially adopted because people still have antiquated views about the US system, which I think functions pretty well. So with that, maybe I've set up some questions for you, and I'm happy to talk about
So how about Glenn, can you give us your perspective coming from the Defense Council perspective and both what's happening globally and then over here as well?
Sure. A few things. First of all, thank you for having me. I'm happy to be here. And like Jeroen, the views I express are my own, not those of my firm, Mayer Brown, but I'm happy to speak freely now with that caveat. And let me start with a couple of points that Jeroen touched on that I agree with, and maybe give a slightly different perspective on a couple of them. First of all, I agree with Jeroen. He touched on this, that the vast majority of filings, let there be no doubt, that the United States remains the center of the universe for securities class action filings. The vast majority remain filed and litigated here in the United States. But I also agree with Jeroen that you will see an increasing trend toward litigation on foreign soil, particularly as those legal systems develop, and they develop rules of consistency and certainty for issuers and for plaintiffs alike. Because I think whichever side of the V you may be on, litigants are most often looking for some certainty and some guidance into how the litigation might proceed, what the possible range of outcomes may be, so that they might assess litigation risk, again, on both sides, both the plaintiff and defense side. And on the foreign collective actions, class action-like vehicles in other countries, what we continue to see is a development of that law. And as that law continues to develop, you'll have increased certainty for both plaintiffs and defendants. The other point that Jeroen touched on, and I just want to mention very briefly, is that while Morrison did decide once and for all that foreign traded securities would not be subject to jurisdiction in securities class actions in the US, although we're a decade on now, we're 10 years on, almost exactly 10 years on now from Morrison, there continues to be some confusion in the lower courts about how that exactly applies. And foreign issuers do still remain subject to US jurisdiction for securities that might be traded in the US on US platforms and the like. And we saw that relatively recently here. I'm in California. We saw that in the Ninth Circuit with the Toshiba case, where you had unsponsored Toshiba ADRs here in the US traded on domestic platforms here in the US. And although the fraud allegedly occurred in Japan, the regulatory investigations occurred in Japan, the ADRs were not sponsored by Toshiba. Nonetheless, the Ninth Circuit, overturning the district court, held that those claims may be subject to US jurisdiction. And then on remand to Judge Berger, he agreed and denied the motion to dismiss. And so now you have a foreign issuer subject to jurisdiction in the US. So again, the US will remain a hotspot for securities class action for probably the rest of my life and the rest of the lives of everyone listening today. But we should talk about what's happening overseas, because that bears some importance as well. And here's one area where I have a very slightly different view than Jeroen. And what Jeroen said is that human nature is greed. So long as there's greed, there will be fraud. So long as there's fraud, there will be investors seeking an avenue for redress. And I agree with that part of it. But I also think there's something else that will be driving the growth that we're likely to see in overseas securities class actions. And that's this fundamental premise, which is that so long as we start to see large settlements, Jeroen mentioned Fortis, I think was over $1 billion. We've seen other, several $100 million settlements in foreign collective actions in Europe. There's also developing law in Canada, Australia, other jurisdictions. And so long as you see plaintiffs and investors succeed in those jurisdictions and secure large settlements in those jurisdictions, that is going to breed interest from representative counsel for those investors, and it's going to breed interest from litigation funders. And the more you see that kind of interest and potential returns for those individuals and those counsel, you're going to see more action. And so it's going to be sort of a circular breeding of these actions. And then it's only going to be, as I said, exacerbated by increased certainty as the law develops. Very briefly, one or two more points, which is from the issuer perspective, and as a defense lawyer, I most often deal with issuers. From the issuer perspective, perhaps the issue of greatest concern with the rise of these collective actions in foreign jurisdictions is the uncertainty it creates, first on the opt-in versus opt-out model, and how that will impact the potential outcomes in the litigation. And second, the uncertainty of the ability to obtain a global settlement if there is in fact a settlement in the litigation. So as we all know, when issuers settle, almost always what they most want out of that settlement is global peace for all investor claims across all jurisdictions, wherever the securities may be traded, wherever the issuer may reside. That doesn't matter so long as they're buying global peace with their dollars or their insurance dollars. And this goes for the D&O insurers as well. And to the extent there continues to be some uncertainty about where these claims may be brought, how they may be settled, and who may be bound by the settlements, that uncertainty is going to remain a concern for issuers, D&O insurers, underwriters, and the like.
So thank you, Glenn, for that. Stephen, I wanted to turn to you now. So just to hear from your perspective, since you represent the investors and doing the third-party filing for them, what do you see as the implications of all this globalization, and to the points that Jeroen and Glenn were making?
Sure. Yeah. Thanks, Robyn, and thanks for the kind words to start. My views tend to be similar. You are seeing increased globalization of class action and collective action opportunities. Like Jeroen, I've been following this probably since the mid-aughts and some of the larger global settlements that were brought in the U.S. before Morrison. I too thought Morrison would show a pretty swift uptick of cases brought outside of the United States, and you're starting to see it really now, about a decade later. In particular, you're seeing a lot of law changes in various countries. Just this year alone, you've seen some new class action or collective action statutes in Scotland, in China. The Netherlands increased their class action statute on January 1st of this year. And then back in June, the EU Parliament passed an EU-wide collective action statute that's going to be implemented by the member states over the next couple of years. So I think the next decade, you're going to see an even greater uptick. And I agree with Jeroen that the percentage of cases brought will continue, outside the US will continue to increase. But again, the US is also very, very active. Last year, in 2019, I believe there were 428 US cases brought, which was a record year. We also saw a number of record filings in the US in 19 involving non-US issuers. I think there were 57, so almost 25% of all core filings. And this year we're on pace to beat that number. So despite Morrison, there are still non-US issuers being brought under US securities laws and brought here in the US. So you're seeing a lot of that activity as well. One thing I wanted to add, and both Glenn and Jeroen talked about it, is the opt-in versus opt-out model. The EU default is going to be an opt-in, just like you'd see in Germany, or for securities cases in the UK. Personally, I find that a little surprising. If you get behind sort of the EU Parliament's thinking about passing a law, they're looking for access to justice for EU citizens. And an opt-in model is not as friendly in that regard, specifically with securities cases. When you look at the opt-in cases brought around the world, they tend to be for large institutional investors and not the individuals. Their losses tend to be too small to get involved early in a litigation, as opposed to in the US model, after there's a settlement or a judgment where they can file a claim and participate and be part of the process. So as that continues to develop in foreign law, I think it's going to be interesting to see how that plays out.
Great, thank you, Steve. Just picking up on Glenn, something you had brought up earlier about the third-party litigation funders. We see that's a big trend happening. Did you want to speak a little bit more to that and how that's kind of a driving force in increasing the litigation and what some of the implications might be to that?
Yeah, and I think Jeroen should weigh in as well from the plaintiff's perspective, because from the defense perspective, look, I mean, I guess our view is that these claims are going to be brought whether they are funded by litigation funders or not. There are enough players in the field, there are enough representatives for investors and shareholders that they're going to bring claims wherever they might be. So it impacts more the ability of certain, I think, firms to get into the game and increase competition for investor plaintiffs in those cases. My point was a more simple one, which is simply that as these collective actions gain ground in foreign jurisdictions, and as we see larger settlements, you're going to have increased attraction from litigation funders who also want to get a piece of that. And so I think you're going to see them incentivized to bring cases. But will that drive enough more cases? I don't see that from the defense perspective, but Jeroen may have a different view.
So yeah, I'm happy to weigh in. So I would distinguish between the US and mostly Europe and Asia. So in the US, there are litigation funders, but the truth is for the major securities class actions, there's a handful of firms, my firm and 4 or 5 others, that do the real significant cases, and we all fund our own cases. And so there is no need for litigation funding, and they don't have a meaningful role with respect to the important cases. I'm not talking about the smaller cases that virtually all get dismissed on a motion to dismiss before any discovery. I have no idea about that practice. But if you look at the 4 or 5 dominant firms on the plaintiff side, we all fund our own cases. And so it really has no impact, I think, on the good cases and the number of good cases that get filed. In Europe and in Asia, it's different. And it is different because in most jurisdictions outside the United States, until very recently, that too is changing now. But until very recently, lawyers could not work on a contingency fee. They needed to be charging an hourly rate. And so then the question is, who's going to be funding these litigations when individual claimants may not have a sufficient stake to do so, but as a class or as a group, an opt-in group, you have sufficient capital to actually do that. And that's where the litigation funders came in, and they filled a need. And I completely agree with Glenn. I mean, if you see that there's a more certainty of recovery and the recoveries are going up, then there is a need to be filled. It's the way of capitalism. Somebody's going to fill that need. And so I have no issue with that. And litigation funders filled that need mostly in Europe and in Asia. And some of my competitors here in the United States effectively became litigation funders in Europe. So it wasn't just litigation funders that were only funding litigation. Some of my competitor firms here became litigation funders outside and brought their expertise with US cases to those non-US cases. And it's a pure financial play, right? It's basically a risk-reward analysis. And so they are, for sure, critically important for non-US cases. And that is still going to be the case for a long time to come because of the rules prohibiting lawyers from working on a pure contingency fee basis. Like, just a very quick anecdote. When I was an attorney in the Netherlands before I came here, went back to law school and became an attorney here. And in the Netherlands, as an attorney, it was a profession. I was wearing a black robe. I was speaking on behalf of the law. And then I came here in the United States, and law is still a profession, but it's also a business. That idea that law is a business is anathema to many of the jurisdictions in Europe and in Asia. And so as long as that is the case and there's no contingency fee possibility for attorneys, you're going to have litigation funders, and that's creating its own challenges, right? I mean, the question then becomes, who is really driving litigation? And if you're a defendant, who am I interacting with? Am I interacting with the litigation funder that has its own interests? Am I interacting with a group of plaintiffs representing by their attorneys? And that can potentially create issues, obviously, about interests that are not always aligned, and who do you deal with from the defendant side? So I think that that's an added complication that's not going to go away anytime soon.
Thank you, Jeroen. So as you said, there's that big distinction between the international, global versus the US. So with that, I'm going to move on to our next topic and bring Dean here in on this on our federal versus state. So recently in the San Mateo Superior Court, there was a recent decision of Wong versus the Restoration Robotics regarding securities class actions in state court in California and elsewhere. So Dean, can you give us some highlights on that and also how it relates with the Delaware decision earlier this year?
Sure thing, and thank you guys for having me here today. And I'll apologize in advance if any of the construction going on in my apartment building bleeds into our panel, but hopefully that won't be a problem. So just kind of start off, I mean, I think the federal versus state court debate for securities litigators, at least in its contemporary form, is just building off of the March 2018 Supreme Court decision in Scion versus Beaver County. And it was found there that federal and state courts have concurrent jurisdiction over Securities Act 1933 claims. Now, I think the decision itself was largely textual, and it was just this belief that there was a holding that Securities Litigation Uniform Standards Act didn't actually strip state courts of that concurrent jurisdiction. And I think there was a belief early on in 2018 that the Scion decision was going to drive weaker Section 11 claims from the 1933 Act, or Section 11 claims that weren't already tied with 34 Act claims, to the state courts, where shareholder suits are generally less likely to be dismissed than in federal courts. And born from that was what was initially called the Grundfest Clause, which was proposed by Professor Joe Grundfest out of Stanford University. But that's now widely being referred to as the federal forum provision, or at least that's how that clause is being put into public companies' bylaws. And the Grundfest Clause was essentially used for companies that wanted to avoid duplicative litigation in both federal and state courts. And it was a provision that just required public company shareholders to take all of their 1933 Act claims to federal court. So as a result, I think that since Scion, the big point of contention in this forum war is just trying to figure out the validity of those federal forum provisions. And the most exciting thing that's come from that question happened actually just this month. So as you had said earlier this year in March, the Delaware Supreme Court found that Delaware law doesn't prohibit companies from adopting these federal forum provisions. And that wasn't necessarily unexpected. What was somewhat unexpected, I think, was the ruling that came from the county of San Mateo earlier this month, in which the judge spent a really long time criticizing the Delaware Supreme Court for the way that it reached its conclusions. She was very critical of the analysis that was used, and it's the way that it's sort of bounced off of the Scion decision. But in kind of a twist ending, the California state judge reached the same conclusion as the Delaware Supreme Court in finding that at least the federal forum provision being used by Restoration Robotics was enforceable. And the reason that she made that conclusion was just a finding that it wasn't unjust or unreasonable, and that it didn't deny shareholders their due process. The ruling itself was interesting for a lot of reasons, not the least of which being that the California judiciary doesn't usually rule in ways that at least appear to favor corporations and disfavor investors. But what's really driven discussion around that judge's findings is her conclusion that federal courts provide investors with greater authority to attain personal jurisdiction over defendants and to subpoena witnesses to trial. So I think those findings ultimately speak to the broader discussion of, why it is that it's at least perceived that investor plaintiffs want to bring their Section 1133 Act claims to state courts when they're ostensibly afforded more avenues to success in federal court.
Great. So with that, we've got I want to hear both the plaintiff's perspective on this and the defense perspective on this, but I'm going to actually put up a poll question that I'm going to launch right now, which basically is saying, presumably, defense counsel prefers securities cases in federal court, plaintiff counsel prefer to argue in state court. Which do you think provides the better outcome? So while I'm getting the poll results, Jeroen, do you want to give your perspective?
Yeah, and actually, I was getting a little distracted because I'm seeing the poll results come in live.
I know.
So I'm just going to click that out. So my perspective is as follows. I think that this was a problem that was like a solution looking for a problem. I really did not think this was such a big problem. It was only Section 11 claims, right? Not all securities litigation. And even then, it was only one or two firms that were really pursuing claims in state court, almost all in California. And so there was a lot of brouhaha about Scion, and I was on a lot of panels at the time. I was like, what I'm about to say now. I was like, what's the big deal? Like, you go to state court. What is wrong with state court? State court, they're good judges and they're really smart people. And what's your problem? And I thought then, and I still think now that, and this is going to be a little provocative for Glenn, but that many of my defense colleagues that I have a lot of cases against, right? The Mayor Browns and Sidley Austins and the Cravats and the Wachtels of this world, typically are just more comfortable in federal court. Like, they're just happier in federal court because that's where they are all the time. And I really did not think it was such a big deal that sometimes you needed to defend a Section 11 claim in state court. And I still think that today, Dean said something that I don't necessarily agree with. And that was that it wasn't a surprise that the Delaware Supreme Court came out the way it did. It was actually a surprise to me because I thought that Vice Chancellor Laster's opinion was very well reasoned and made a lot of sense to me. I saw the argument done before the Supreme Court, and I thought that, the representative of the plaintiffs did a very, very good job. And so I was actually kind of surprised with the way the Delaware Supreme Court came out. Now, do I think it is a calamity that they did that? No, because I'm perfectly happy in federal court too. I have no issue with that. But, that's sort of my quick 2 cents.
And Glenn, what about you from your perspective?
Sure, a few takeaways. First of all, I'm comfortable in court. So whether it be state or federal, you're on. But in all seriousness, a couple of takeaways. First, the more recent restoration robotics decision here in California out of San Mateo, I think particularly for anybody that practices in California, we understand, I think both the plaintiffs and the defense counsel, that is not the last word on this issue, at least in California. California superior courts are not binding on even other courts in the same county, much less on counties throughout the state. It'll be interesting. I don't think the plaintiffs filed an appeal in that case, which may be because they don't want to obtain an adverse appellate ruling that might be have more precedential value throughout the state. I don't know what the reasoning is, but in any event, even that, I can tell you that in California Court of Appeal decisions aren't always viewed as binding by the trial courts throughout the state. So by no means is the ruling in restoration robotics the last word on this issue. Even within the ruling itself, there are avenues for possible dispute by plaintiffs and defendants going forward on other 33 Act claims that might be brought in California state court. So for example, the judge in restoration robotics seemed to put some weight on the fact that the federal forum provision that was implicated there was subject to a shareholder vote before the litigation was commenced. And so it was effectively approved by shareholders. So we don't know, for example, if a company implements a bylaw amendment to enact a federal forum provision, if that will be viewed with the same weight or the same authority as it was in restoration robotics. So I think there are still questions, many questions that remain about how that will impact. I also agree with Jeroen and Dean that, by the way, this was specific to 33 Act claims. It doesn't necessarily implicate the Exchange Act claims, and so those are still going to be issues going forward. As to the defense perspective on federal versus state forums, it's not so much, I think, for most issuers that they have a strong preference to be in federal court over state court. There's certainly some reasons to have that preference. The PSLRA and its pleading requirements and the like in federal court are important defense mechanisms for issuers. Generally the judges are more familiar with securities claims and how those play out and some of the unique elements of litigation in the securities arena. Certainly the numbers bear out that the outcomes, particularly for dismissal, are more favorable for defendants in federal court than they are in state court. But one other issue that hasn't been touched upon is the risk, burden, expense, distraction, et cetera, of duplicative litigation, because it's not as if we see plaintiff firms filing just a state court action or just a federal court action. It's when both are filed that create essential heartburn for issuers. They don't want to obtain a dismissal in federal court, for example, and then have to slug it out in state court when they've already obtained a dismissal. They don't want to have to slug it out in both federal and state court over essentially duplicative claims. And I think what Professor Grunfest, who I had the great opportunity to work with both before law school and study under when I was in school, I think one of the things that Professor Grunfest was getting at with his suggestion for these federal forum provisions was that it's an opportunity for issuers to do away with the inherent burden, expense, and uncertainty of having duplicative claims in multiple forums. And that's essentially what I think is top of mind for issuers. The last point I'll make with respect to both the Salzburg decision in Delaware and the restoration robotics decision here in California is that it doesn't yet speak to what this means for other parties in the case, other than the issuers. It doesn't speak to what happens with respect to underwriters, for example. It'll be interesting to see how that plays out, as I assume that underwriter defendants will try to avail themselves of the federal forum provisions in the issuer's charter or bylaws. So for example, by arguing that they are an intended third-party beneficiary, or that it was reasonably foreseeable that they would be a beneficiary of the federal forum provision. I think you will continue to see those kinds of arguments made, and that will have to play out as well. So for now, we're going to continue to see Securities Act claims brought in state court, and we're going to continue to see them brought for Delaware corporations. We're going to continue to see them brought in California, because this is by no means a settled issue.
Thank you, Glenn. And so I want to bring Steve in here now, because based on our results, this was a question about what's the best outcome for investors. So Steve, what would you like to add to?
Yeah, thanks, Robyn. So exactly, I think about this not as a litigant, but from the investor's perspective. And if you look at the poll results, it's close, but leaning towards federal from the investor's perspective, which I agree with. And for a lot of the reasons that Glenn was just talking about, I think investors' interests, at least in early stages of litigation, tend to be aligned with the issuer. They own a piece of the company, and so they're invested in my view, in wanting to keep costs down, particularly for for frivolous claims and frivolous lawsuits. So I think being in federal court and having the heightened pleading standards under the PSLRA is a good thing. Of course, it flips when you have a misconduct and you have fraudulent activity or mishandling that results in a stock drop and in a 33 Act claim. So in those cases, investors want to be able to maximize their recovery and their opportunity and get back as much of their investment as they can. And federal court's a good forum for that.
Great, thank you. I think we see this will be an ongoing debate. So now moving on to our next topic about the impact of COVID, I wanted to bring Dean in to start this. I mean, basically, we had seen when the pandemic had started, there was thoughts that there'd be a flurry of cases, specifically securities cases. And, there's been some, but we haven't seen a significant amount. And, depending on what industry and so forth, there's various implications. And so, Dean, can you give us a little bit of overview and color around what was anticipated and what's actually happening?
Sure, and like you had said, I think early on there was an almost instinctual expectation, probably based just on the rise of event-driven litigation that we've seen over the last 10 years. There was an instinctual expectation that there was going to be there was going to be a lot of securities litigation coming out of the pandemic. And early on, there was certainly some. We saw, I think, among the earliest was the case against Norwegian Cruise Line. There were claims that its sales reps were being pressured to downplay the virus to potential customers. Pretty soon after that, we saw a big suit filed against Inovio Pharmaceuticals over its, I think, mid-February claims that it was working on a vaccine that got touted on Fox News and then later proven to be, or not proven, but demonstrated to be possibly not true. And so I think that that was expected to see travel and pharmaceutical industries being the first ones looped into all of this. And as of mid-July, so as of a couple of months ago, we had at least 55 securities cases being filed with a direct connection to the pandemic. And most of those have targeted companies over their disclosures, either about their business operations as they relate to battling the vaccine or in response to new challenges being created within their industry, or having to do with the financial projections that they were releasing and as the degree to which they accounted for the impact of the pandemic. But all of that said, there certainly hasn't been this big glut of cases that may have been expected. And there's a few reasons for that. Really early on, I think a lot of commentators who noted the potential for a rise in litigation here also noted the difficulties that were going to come up in trying to prove loss causation for any sort of securities case with a class period that overlapped with the market volatility we saw in March, pretty directly from the pandemic. So when there's a ton of market volatility, it gets harder to necessarily prove that one company's stock fluctuations were the result of a fraud and not the result of wider market influences. But I think the other thing the other reason we might not see a ton of securities litigation born from this right now is just that it's still early. A lot of times, securities cases will kind of lag behind the class periods that they're looking to examine a company's behavior under. And so in that sense, we might just need more time for legitimate frauds to be sort of sussed out by plaintiff firms, and then we may see a heightened amount of litigation.
So following up on your points, you said it is still early, but Glenn or Jeroen, can you speak to the point that Dean was making about the market volatility? I know it still has to be played out, but that compared to what we had in other times of, the 2000s and dot-coms and all that type of stuff, what you think that how that'll play out and how it differs.
Sure. Well, I think the prognostications that Dean was alluding to, and I think he described it as an almost instinctual reaction to the market volatility we saw, particularly in late March. I agree with that. I think that at that time, that's when there was sort of a rush to guess what this would all mean, and the guess was an easy one, which is, we're going to see a replay of the last financial crisis or the dot-com bubble bursting in the early 2000s, something along those lines. And that did in fact play out that way. And I think one of the big differences, obviously, is that those prior period market volatility periods were prolonged periods of market volatility and declines. And instead, what we saw here, inexplicably, is an incredible rebound in at least the public trading markets here in the US. Shortly after the March 23 significant drop that we saw then. And so you're going to still have, I think, to the extent there are suits brought, and there have been, as Dean mentioned, the cruise line suits, the pharmaceutical suits, there have been a few that have been directly tied to the pandemic. There have also been some more creative suits brought. So for example, in the Elanco case, the allegation there was that the company adequately disclosed the potential impact on revenues of the pandemic, but at the same time, the company had downplayed or omitted to disclose implications for inventory backlog that they were experiencing. They were somewhat unrelated to the pandemic. And I think the basic allegation there is that the company used the pandemic to mask a bigger problem. So they forecast declining revenues. And so there's a more creative use of the pandemic in pleading a securities class action. And so we might see a few cases like that because plaintiffs' attorneys like Jeroen, if nothing else, they're very creative. And I give them lots and lots of credit for that. I truly do. And so, you may see some cases arising out of that. But by and large, plaintiffs are still going to have to plead loss causation, and that particular, discrete stock drops are sufficiently related in time and magnitude to discrete company-specific events. And defendants are still going to have to be able to plausibly argue at the pleading stage and beyond that those stock drops are not specifically related to company events, but are instead related to a broader market event, market volatility, market declines, and the like. And again, the big distinction being that we don't have a prolonged period of that here, at least not yet. The last question, then I'll pass it to Jeroen, is whether we are in fact going to see longer term impacts of the pandemic. They're going to create as we go forward, because there still remains obviously a lot of uncertainty across the world about what's going to happen in the coming months and even years, whether we will start to see longer periods of market volatility or market declines. And if we do, whether there will be suits related specifically to the pandemic, the cruise line type suits, I'll call them, or whether we'll start to see, as Jeroen would prognosticate, I think, frauds uncovered. And that's where we might see something that is more akin to what we saw during the last financial crisis and during the dot-com bubble deflating in the early 2000s, is that not only did we see companies driven, their prices driven lower during those periods, but we saw the accounting frauds of the day being uncovered because they were no longer sustainable because of those outward market forces. And I think that's the question that really we're all waiting for an answer on over the next months and years.
So, Jeroen, since you're, as a plaintiff attorney, very creative, can you give us your perspective on, what you see with that and what some of these prolonged implications could be?
Yeah, sure. So first of all, yes, we are very creative. We are also human and also rational. And there are some profound differences between the pandemic and the financial crisis and the dot-com bubble. The first one is when the pandemic hit, like everybody else, you're just battening down the hatches and just trying to figure out what is going on. Like, you're not looking for cases, you're not like bringing lawsuits, you're actually just trying to figure out what's going on and how we're going to survive collectively as a city. I'm here in New York, which of course was really heavily hit. And the last thing on your mind is like being creative and bringing cases. You're just trying to keep your loved ones safe. But then we also then got together very quickly at my firm, and I'm confident other firms were the same, where we're like, we are not in the business of taking advantage or profiting off of a pandemic. We're not. we are in the business of detecting fraud, misrepresentations, and recovering losses relating to that. And that is one of the profound differences between the financial crisis and the dot-com bubble on the one hand, and the pandemic on the other. Because I'd be curious if people disagree, but the financial crisis did involve a fair amount of fraud. I mean, people had false mortgage applications that were then securitized and then put on balance sheets of large financial institutions that then made representations about the solidity and the ratios of their balance sheets. There were misrepresentations and there was fraud. With the pandemic, that's a very different situation, right? Like, it's not a situation where you have a financial fraud magnified by a lot. No, it's like a natural disaster that is hitting everybody. So that, I think, explains partially why the response now is different from the financial crisis, because the pandemic itself does not involve fraud. It is just an awful event that is happening. I do think that if you think about the longer term ramifications, we have been going through a market that has, in my view, irrationally continued to go up. Right? The company announces really bad results. It may be a fraud. It may not be a fraud. I leave that in the middle, but the stock goes up. Well, even if I thought it was a fraud, I'm not going to be bringing that case, right? I mean, we invest a lot of money. I mean, we go back to the litigation funders, but we invest a lot of time and a lot of money in our cases. And why would I do that if upfront I know that no matter what I show on the representations and the state of mind of the people who made those representations, there are no damages? And so one of the things that we do see with respect to the pandemic and the cases that have been filed is an increased difficulty in showing loss causation during that period, right? I mean, specifically for the securities fraud cases where we have the burden. I think Section 11 cases may be different. But in securities fraud case where we have the burden, we now have to figure out and disaggregate how much of the stock drop can be attributed to the fraud and how much of the stock drop can be attributed to the pandemic. And well, we'll have an expert and Glenn will have his expert, but then we have a judge, summary judgment. Then we have a jury who has gone through this entire pandemic. It changes the calculation. So I think that's another reason why nobody's rushing to file a lot of, certainly not us, are rushing to file a lot of cases because it's an added complication. And therefore, you have to have even stronger evidence, I think, that the fraud actually caused certain damages.
Great. And so, talking about just in general logistics and everything, one of the things that people were concerned about was with the pandemic, the closure of the courts and what would that impact be? And so knowing that seems they've been somewhat adept, can anybody jump in here on, what do we think that impacts the pace of the securities cases?
So I don't think that they've been somewhat adept. I think they've been remarkably adept.
Mm-hmm.
Like it
Pleasantly
has been
surprised.
Incredible. I mean, I didn't have a lot of expectations. Like I said earlier, I was just trying to survive. So I wasn't really thinking about it. But I have been really impressed with the federal courts around the country, the Delaware Chancery Court, where I have a lot of my practice also, like all of the courts virtually instantaneously, not entirely, but virtually instantaneously, switched to Zoom, switched to hearings in person, and continue to do their work. The only issue that I see is that there's an enormous backlog of jury trials. And there are a lot of people incarcerated currently that are waiting for their trial. And so what I see in the federal courts is, correctly in my view, they are putting the criminal trials before the civil trials. And so you have, not all of them, but most of them. And so what you see is a backlog of civil trials. Obviously, I have civil cases. So that does have an impact on my cases, right? Because the certainty of the trial certainly focuses the minds of everybody involved, us and the defendants. And that certainty is being pushed back a little bit. But as for motion practice, no, it's been seamless. I've been really impressed.
So that's from the practitioner's standpoint. Dean, is there anything you want to add to that in terms of what you've been kind of reporting and seeing in the trends there?
I can just only agree. I mean, we've tried to keep a general tracking of how much securities litigation in total is filed each year. And the first half of 2020 was a little lower than the first half of 2019, but historically has continued the upward trend. So there certainly hasn't been a reduction that we might have expected. And as Jeroen was sort of saying, if there is sort of a backlog in trials, I guess the one upside of securities litigation is how infrequently we actually go to trial. So yeah, as far as discovery and motion practice, we really haven't seen any substantial slowdowns.
Great. Okay. And that leads us to our next topic about general trends. And so one of the things that COVID brings up is, Steve, I'm going to let you speak to this. If we've kind of seen the shift from accounting fraud cases to event-driven, the most recent being COVID, kind of some of the marquee ones that really began some of this major event-driven was BP and so forth. So Steve, I wanted to let you kind of speak to that and see where kind of the shift of what's happening there.
Yeah, sure. We've already talked about some of the trends, such as globalization and increased volumes. But the increased volumes, in my view, is in large part due to the event-driven litigation we've been seeing, which COVID-19 is really a part of. Traditionally, these stock drop cases were around accounting fraud, your Enrons and WorldCom and cases like that. But we've seen a real shift towards companies being sued around their preparation for or handling of an event. The BP oil spill you mentioned was a good one. There was obviously a very large class action surrounding the damage caused down in the Gulf, but there was also a significant stock drop case that followed that. You saw it with Volkswagen and the emissions scandal. Again, you had the class actions around the cars themselves, but you also had the corresponding stock drop case. Data breach became a big one, and then of course sexual harassment and the Me Too movement, and now you're seeing it, in COVID. And I think we're going to continue seeing this in 2020 and going forward. And so I think it'll be a little bit hard to predict kind of what areas you're going to see additional securities fraud, because it's going to surround conduct or activity in a lot of ways. Open questions are, will there be things around board diversity and ESG? I think those are things that could be explored. The second trend that I wanted to just touch on briefly is really around industry. Again, historically, you looked a lot at the financial services market in terms of defendants and people who were being sued for fraudulent cases, but there's been a trend downward the last couple of years in terms of number of cases filed against the financial market. And you've seen new industries coming about. In 2018, you saw a couple of dozen cryptocurrency cases or ICO cases. This past year, there were, I think, 16 cases against cannabis companies, with that growing industry in Canada and being legalized throughout the United States, and you're seeing a lot more of that. So I think you're going to see continued trends in industry. You're even seeing that of course, with the COVID cases. You're seeing that in travel, and in the pharma medical companies.
Great. I didn't know if anybody, Dean, if you had anything you wanted to add to that in terms of kind of the shifting trends and where we might see that next major wave.
Sure. I would touch a little bit on what Steve said about event-driven litigation. A lot of plaintiff firms that I talked to, they sort of see event-driven litigation to be sort of paralleled with the concept of shareholder activism, or shareholders using their ability to bring litigation to enact some broader change, whether that's by a class action or by a derivative suit. I think that there has been, just sort of as we had said, with each new large event, be it the financial crisis 10 years ago or COVID-19 now, there seems to be a parallel set of litigation. And I think the one that we might see coming up soon is the broad push for social justice that we're seeing more and more of this year. Now, a lot of the cases, I think that we had talked about the idea of using litigation to impact diversity on the boards of major companies. We have seen a lot of lawsuits filed that have targeted Oracle and Facebook and Monster Energy and Qualcomm for that exact type of sort of what's considered a misrepresentation by these companies about diversifying their board. Now, all of those did come from one law firm in California. But that said, I think that they are keying into something broader, which is just the idea that shareholders can try to enact these changes using securities law. I like to think about the fact that earlier this year, there was a major settlement with Signet Jewelers that I think Bernstein was the plaintiff firm behind. And that was targeting Signet for what was considered misrepresentations in their code of conduct about sexual harassment. But those claims were based primarily on finding or allegations of sexual harassment at Signet that was sort of paralleling the Me Too movement. So I think that if we can find, if they can find that success in the Signet claim to at least get those claims certified or get class certification for those claims, I got to think that that will only embolden shareholders to push for other changes in a similar way.
Jeroen, since he just mentioned Bernstein and your firm, did you want to discuss it? I know we had previous discussions talked about, would this be kind of down the road of derivatives case versus a securities case as we're looking at holding boards accountable. Can you speak to that?
Yeah, yes. So I have a slightly different perspective than Dean and Steve. So, I think that what they refer to as event-driven litigation, to me, that's not a trend. It is more like a one-off here, a one-off there. When we talk about securities class actions, okay? When we talk about derivative cases, and I'll talk about that in a second, I think it's a different ballgame. When we are talking about a securities class action, we are governed by the 34 Act and the 33 Act and the PSLRA, and it needs to fit in those structures. And so if it doesn't, it doesn't, right? And we also had the Volkswagen ADR case in San Francisco, but it was really a fraud about the we said about the representations that Volkswagen was making about its cars. It still needs to fit within that paradigm. So when I think about trends in securities class actions, I don't think about those event-driven type situations, because to me, they're not trends. They're like, oh yeah, it happened one time here, one time there. When I think about trends, I think about first, there's been a migration of M&A related litigation from Delaware Chancery Court to the federal courts, and that followed Chancellor Bouchard's decision in Trulia, which I thought was an eminently reasonable decision. I fully supported it. In fact, I wrote a law review article about it a year before the decision came out. Sadly, he did not cite it, but I completely agreed with that premise, right? That migration of M&A related, what I would call mostly, not entirely, mostly frivolous M&A litigation to federal court, that was a trend. And I think what you will see is a trend within the federal courts to say, I don't want this, these frivolous cases either. And so the task, I think, for the federal court and for me as a shareholder lawyer is to make sure that when the federal courts clamp down on that, as they should, they don't throw away the baby with the bathwater and also make it impossible for meritorious claims to be filed. But that to me is a trend you will see. I think you will see fewer and fewer merger cases over time, because over time, the federal courts are going to start adopting a Trulia type measure like the Seventh Circuit did recently. So that to me is a big trend. And if you look at the number of increased cases over time, when people say, well, we have so many more cases, it is virtually always the M&A cases that are included in the tally. If you take them out, the numbers are pretty stable. It's 200, 250 cases a year on one of the most liquid and biggest markets in the world. And so that to me is a big trend. So then thinking about trends going forward within that paradigm, as I privately discussed with you guys before this call, I'm very worried about the accounting firms. I don't think that the accounting firms are a watchdog anymore. I think that there are too few of them. Like there's not the big three or the big four. And they're just not really performing their function anymore. So Wirecard is a good example. Like it's a German company and recently had to come out that they were missing $1 billion in cash from their balance sheet. Cash, not like some remote location plant that you can't get to. This is cash on the balance sheet, and the auditors have been signing off on this for years. So, when I see that, and then when I see decisions where auditors are co-opting and corrupting their regulator, right, the PCAOB, like that to me suggests that there's fundamentally a problem currently with the auditor firms. And if there's a fundamental problem with the auditor firms, that means there's going to be a fundamental problem with the financials down the road. So if I were to make a prediction, I think that's where you're going to see most of the securities class actions.
Great, and we've just got 1 or 2 minutes left, and I'd be remiss if we don't address that in 40-some days we've got an election coming up. And so wanted to just get some quick color. Maybe Glenn, you can speak to what you think the implications of a Trump presidency or Biden, and then obviously with all the judicial appointments that we've had, what some of that implication has been. So if you could just do a brief synopsis on it, that'd be great.
Yes, I'll do this very briefly because I know we're running out of time, but I think there's two key points that turn potentially on the outcome of the election. The first is what we will see in regards to government enforcement activity. SEC, DOJ, and other regulators. It has been well documented now that we have seen a substantial decline in what I'll broadly refer to as white collar matters investigated and brought by the DOJ, and then security specific enforcement matters investigated and brought by the SEC. And as we know, there is some correlation between security shareholder actions and government enforcement activity, because sometimes, frankly, the government does the work for the plaintiff's lawyers and identifies frauds and the like. The second key area is judicial appointments, and we've seen, an astounding number of appointments to the bench by President Trump. We've seen that these are mostly extraordinarily conservative individuals who tend to be on the much younger side. That will have ramifications for years to come on the federal judiciary. And whether that he's able to continue to do that post-November obviously will be determined by the outcome of the election. From a securities class action standpoint, the biggest question mark that raises is whether those judges will be able to faithfully apply the PSLRA standards, because the basic reality in lay terms is that securities class actions are a very unique vehicle. They're unlike any other, and they're subject to a statutory scheme unlike any other class action vehicle. And some judges just frankly aren't familiar with it. They don't understand the scienter pleading standards, for example, or how they're applied by their circuit courts and the like. And that's not to knock them. They're all trying to do their best and they're all trying to get it right, but sometimes they just don't. And whether some of these relatively inexperienced judges are able to do that and are able to be educated on that, it's really up to us as lawyers. It's up to Jeroen and me to educate the judges on the standards and to ensure that they faithfully apply them. But I think it remains to be seen whether conservative judicial appointments, by and large, will have a significant impact on the outcomes of these cases or not. And we'll wait and see.
Well, thank you, everyone. I know we're out of time now, so thank you for that terrific, robust discussion and hearing from all different viewpoints. So I will turn it back to my colleague, Chris, and he can tee us up for tomorrow's nice full day of conference. Thank you.
Thank you.
Okay. Thank you, Robyn. Robyn, Steve, Dean, Jeroen, and Glenn, thank you. Securities law is such an important practice area. We appreciate your insights about the sector. Now that does bring us to the conclusion of today's program. We will resume tomorrow at 11 a.m. Eastern for the final day of our 3-day conference. You should have received an email from Zoom today, which contains your unique login link for tomorrow's program. If you didn't receive this email, you will need to register again on our website, classactionconference.com. Thank you for joining us today. We look forward to seeing you all tomorrow.